few years back, I finished a 5-year appointment as a settlement monitor in a state prison system in a civil rights case that was about deaf and hard of hearing prisoners, people incarcerated there. That means I was appointed by a federal court to spend time in the state's prisons, talking to prisoners and staff and reviewing records and facilities. And I saw some really obvious problems. I recall one deaf prisoner who used American Sign Language to communicate, and he couldn't speak at all. He was found to have committed a disciplinary infraction at a proceeding where he had handcuffs, so he couldn't sign. So they held him without communication and found him responsible for an assault without hearing what he had to say about what had happened. Or another deaf prisoner who also signed to communicate. This one, he was illiterate. He couldn't read at all besides not being able to speak or hear. And he sat incommunicado at a parole hearing where he was asked why he should get parole, but couldn't hear the question and couldn't respond with an answer. And he was communicated with by somebody passing him notes, but he was illiterate and couldn't read them. So these were really obvious problems. And some of them, many of them actually, were able to be solved right at the beginning. But other problems were less obvious and harder. Prisons are extremely noisy. They're congregate settings with lots of people. They have hard surfaces, they're crowded, their spaces jammed together with a lot of functions. And this is a stressor for really anybody who's inside. But for a person with poor hearing, you really just couldn't design a worse environment. Hard of hearing people are an increasing group behind bars. And over, I saw them unable to access both necessities and other opportunities, unable to hear pill call, unable to hear announcements about programs, unable to hear when meals were happening, and all other kinds of things. Over and over, their access to their families was undermined because they couldn't hear on the phone to make phone calls, and that was the communication method that was provided. So prompted by the lawsuit, the prison system knew that they had to solve those first set of issues, the obvious ones, the ones about people who signed to communicate. They knew they needed to provide interpreters. They knew that they had to substitute other security measures for handcuffs for people who signed to communicate. They knew they had to install video phones. But for each solution, they had to take the needs of people who were deaf into account. And some of that was hard, but the process was relatively straightforward. For the second group of issues, the less obvious ones, there actually were similarly easy methods available to solve the problems. Phones with amplification, visual or tactile alerts, better access to hearing aids, lots of other kinds of modifications to the policies that were running in this prison, lots of changes to business as usual. But it took years to get the prison's attention to focus on those less obvious problems, to institutionalize the expertise and attitude shift that was needed to facilitate solutions. In my talk today, I want to make two overarching points. The first one is suggested by that experience that I just described. It is that disability law and equality for people with disabilities require a different approach than business as usual. What's needed is individualization and accommodation, where the individual needs of people with disabilities are incorporated as a matter of new normal, into official decision-making, and are outweighed only when there's a really muscular reason to outweigh them, such as serious safety risks. My second point, which I'll make more briefly, is that there's an insight there that goes much broader than disability. Both of these points apply, both in and out of prison, but the need to act is especially urgent behind bars. Prisons are really rigid, both because all large institutions have a certain amount of rigidity, and because the ideology of locking people up rests on understanding that those people as less worthy than others of individualization, adjustment, regard, consideration. So prison officials are really accustomed to the idea that prisoners make accommodations to life behind bars. They don't get accommodations. Equality for people with disabilities and bringing more humanity into our bloated carceral system requires change. Okay, let me take a step back. We throw around the phrase mass incarceration without thinking about what a new phenomenon it is. But it is. In my lifetime, and to be specific, in 1972, which was the lowest point, there were 350,000 people locked up in the United States. 350,000. That was an incarceration rate of 1.7 per thousand people. In 2007, which is the peak, we locked up 2.3 million people at an unprecedented rate of 7.6 per thousand. The COVID pandemic moderated things a bit, and right now we've got about 1.8 million people behind bars. But just to get a sense of what numbers like that means that a man who's born in 2000, which is the year my son was born, a man who's born in 2000 has about a 1 in 11 chance of serving a term of incarceration in this country. Not just a night in jail because of something or other. A term of incarceration, a sentenced term of incarceration, 1 in 11. The point is that we are currently in this country, a few decades in one of the largest experiments in human history, which is to see whether it's a good idea to cage millions of people for long periods of time. And so far that experiment is failing. Imprisonment at the scale we use it, at the sentences that we impose, doesn't make sense in terms of crime reduction, and the evidence is clear. It hurts the people behind bars, it undermines their physical and mental health, it undermines their economic prospects for when they get out, which they nearly all do, it undermines their communities, it hurts their families, and it's a waste of human potential that hurts all of us. So it's my profound hope that as a polity, we're going to reverse course and do something different. That the dip in incarceration that's been happening, little bit of progress since 2007 will sustain. And we will put fewer people behind bars, lock fewer people in cages. But in the meantime, I spend my career thinking about what happens to people who are inside behind bars, and how they are treated. So today I want to happen to about a really significant proportion of them who have disabilities. So the key fact about prisons and disability is this: most American prisoners have at least one disability. Depending on the definition, 4% to 10% have an intellectual disability. Over half report symptoms that meet criteria for various mental illnesses, with 15% having symptoms of psychosis, such as delusions or hallucinations. 10% of prisoners report a mobility impairment. Over 6% report that they're deaf or hard of hearing. Over 7% are blind or have low vision that's incapable of being corrected by glasses. 40% of prisoners have some kind of chronic medical condition that impacts their life in a serious way: diabetes, cancer, heart disease. And all of these statistics are for post-conviction prisoners. In jail, it's much, much worse. So the numbers mean that how jails and prisons, how prison and jail officials treat people with disabilities is really far from a niche issue. This is most of the people in the largest carceral experiment in human history. Choices relating to disability are central to the operation of these facilities. They're central to safety and humaneness. They're central to their success or failure in facilitating pro-social community reentry of prisoners when they get out. And again, they mostly get out. So why is disability a challenge behind bars? Sometimes it's because officials affirmatively discriminate against prisoners with disabilities. They bar people with particular disabilities from a job or a set of jobs. They lock them down in their cells. They isolate them in the infirmary. They put them in administrative segregation in solitary confinement. Physical barriers also exclude prisoners with disabilities. But the more general problem is that when the ordinary rules of incarceration they hit prisoners with disabilities much worse. And prisons and jails fail to accommodate their needs. So I want to be clear, incarceration isn't easy for anyone. Sharply limited control over your own routines and arrangements suck, not to put too fine a point on it, but they are worse for people with disabilities. A prisoner with mobility impairments can't readily make their way around prison, given long distances to get to meals or to pill call. Prisoners who are deaf may not hear. Prisoners with intellectual disabilities may not understand the orders that they're told that they have to follow under penalty of physical consequences, of being further locked up, of being isolated, or even having their term of incarceration extended. And many prisoners with either mental or physical disabilities face grave safety threats. They can be vulnerable to extortion and exploitation. They can be manipulated by other prisoners. Solitary confinement is a particular concern. The rate of folks in solitary confinement who have mental disabilities is even higher than the rate in the general population. And people with mental illness commit suicide at an extraordinarily high rate from solitary confinement. The great Judge Felton Henderson wrote several decades ago that for prisoners with mental illness or intellectual disability, solitary confinement is the mental equivalent of putting an asthmatic in a place with little air to breathe. And really, you could think about that as prison more generally. So what's to be done? Well, we need 4 categories of intervention: diversion, accommodation, integration, and treatment. And I'm just going to talk a little bit about accommodation. So, under the Americans with Disabilities Act, there is a really large amount of individualization that is required. The ADA requires, under the term reasonable modification, requires governments to change even-handed policies that hit people with disabilities harder than others. This is the equivalent of what the more familiar phrase reasonable accommodation in employment. In the governmental setting, it's called reasonable modification. And what the law says is that when policies function in a way that is exclusionary, that you have to individualize, you have to consider changes that render those policies less exclusionary. So in prison, the rules are especially inflexible, and so the need is especially great. Prisons and jails are mass institutions, and it's really simpler for them to implement simple rules without case-by-case or more formalized exceptions. Officials will sometimes emphasize that special treatment is a problem, that it can provoke hard feelings or even violence by other prisoners. But in my experience, the inflexibility is really much more a reflexive, automatic kind of response to requests for accommodation. It's just not how prisons and jails respond. They don't like to individualize, they don't like to accommodate. And they're not free to indulge that dislike. The Americans with Disabilities Act tells them they have to, but it hasn't been implemented, even though it's 35 years old. So let's consider what a change could mean. Suppose you've got a prisoner with a mobility impairment who can't walk quickly enough to get to meals on time. Modifications would not be very hard. House the prisoner closer to the chow hall. Allow him additional time for movement, or give him extra time for meals. Or suppose you have a prison where successful completion of substance abuse programming is persuasive evidence of rehabilitation for parole hearings. And it requires coursework, journaling, and the like. And now we've got a prisoner with a learning disability who can't manage that coursework, can't do the reading that's required, can't do the writing that's required. Again, modifications are pretty easy. Provide some tutoring or one-on-one instruction so that he can respond in a way that's individual and oral rather than requiring that he write. Or another one about writing. A prison might provide folks who don't have any money with paper and stamps to allow them to maintain connections with their family and loved ones at home. But if you've got a prisoner who, because of an intellectual disability, is illiterate, she can't use that paper and stamps. Again, modification's not so hard. You could subsidize communication by voice recordings or by phone. You could provide a reader and a writer to assist. This would not be complicated. And finally, prison jobs offer prisoners compensation and they improve parole chances. But many of those jobs include tasks that prisoners with mobility impairments can't manage. Again, an easy modification. Adjust the job tasks or provide adaptive equipment so that the prisoners can manage the tasks. Anybody familiar with disability law outside of prison would think of these as run-of-the-mill, no-brainer implementations of the ADA. These are not rocket science. These are not out there kinds of answers. But in prison, not so much. They're almost unheard of. And so this is the first point of this talk. This needs to change. The kinds of modifications that I just talked about have to become routine. That kind of individualization is required both for legal compliance and also for fairness and equality for people behind bars. And that gets me to the second point, which I'll make in far less time. The change needed is actually, behind bars, again, is actually broader than disability law. It's broader than the needs of people with disabilities. Now, I've already said, my view is that we should be shrinking our prison and jail populations. But in what I hope is the meantime, it's a moral imperative for us to do better behind the folks who we lock up. And it's not only prisoners with disabilities who can benefit from individualization. So I'm just gonna offer one example. I talked about a prisoner who was illiterate and how they can't use subsidized mail and they can't participate in required programming or incentivized programming. Well, what about a prisoner who's illiterate, not because they have an intellectual disability, but just because they never learned to read? And I will tell you that the rate of illiteracy behind bars is extraordinarily high. What about them? Why not do those same kinds of individualizations for that person too? Why wait for the cause to be a disability? Why not just offer people who have different abilities, offer them things that meet them where they are and let them get what they need? So to put the second point more generally, putting disability to one side, we should learn from the disability rights movement, which has for decades emphasized individualization and accommodation as essential to equality. We should learn from the disability rights movement that those approaches, individualization, accommodation, are essential tools for better outcomes, for better policy, for better institutions. Behind bars, the humanity and dignity of nearly 2 million incarcerated people mean that their individual needs and abilities need to be given far heavier weight. We need to not only expect accommodations from them, we need to make accommodations for them to not suffer needlessly while we work on reducing the footprint that is American incarceration. Thanks.